Good afternoon. Welcome to the Baylor Executive LLM and Litigation Management's webinar. We love to share what we're doing in the program, and particularly we love to have the opportunity to have some of our Brain Trust members, our nationally preeminent folks who really are on the leading edge of litigation management, come share just a taste of what you would be learning in the program. I'm joined today by my colleagues in the program, Jim Wren and Kyle Dreyer, and Vito, who, if you are interested in applying, is in charge of recruiting for us. Obviously, we want this to give you a little sample of what you would be learning in our LLM program. Let me shift focus now to our two special guests. We have with us Richard Arsenault. Richard is a named partner in Neblett, Beard, and Arsenault. And while his offices, as you can tell from his background, are in Alexandria, Louisiana, the scope of Richard's practice and influence definitely spread across the nation. He has been at the forefront of handling complex litigation and literally has written the book, right, Richard, on managing complex litigation. And so he has just a wealth of information, and we're so glad that you're here with us today. Also joining us is Mark Lanier from the Lanier Law Firm. You know, many of us get excited when we have verdicts that start with that M word, millions. Mark's kind of ratcheted it up a notch for the rest of us, and he has moved to the new, he's what we call a B-list celebrity, but in this case, that's a billion list celebrity. And so we're very glad to have our A-list, Mr. Arsenault, our B-list, Mr. Lanier, and they're going to spend some time talking with us about litigation management, specifically from the plaintiff's side. So first of all, gentlemen, welcome. We're very glad to have you here. For those of you watching, you'll notice at the bottom of your screen, there is both a chat and a Q&A button. We're really happy for this to be an interactive discussion. So if you have questions, if you want to make a comment, use those buttons and we'll get you in there. So Richard, talk to us about litigation management from the plaintiff's perspective, and how you and Mark know each other.
First of all, thanks for the introduction and thanks for allowing us to participate. Mark and I have known each other for a couple decades, and in the last decade, we've worked very closely together, particularly in the context of MDL trials. I have sat next to Mark in 5 trials, each of which consumed about 3 months, and it has been an amazing experience. His advocacy skills are second to none, and his technology skills are amazing. And what we're going to start with today is a little bit about technology, 2 parts. Part 1 is going to be technology in the courtroom, and this is where Mark is unmatched. In Actos, the Actos MDL, where he earned a $9 billion verdict, and in the Pinnacle MDLs, where he likewise had verdicts exceeding $1 billion, he had witnesses appear remotely through satellite transmission. And one of the challenges with MDLs are you never know where they're going to be. So key witnesses that you would otherwise be able to subpoena if you were in your backyard or if you brought the litigation where the defendant resides, you don't get those people live. And in Actos, for example, we were going to have 20 or 30 depositions because we couldn't get the folks live. So the plan B there was satellite transmission. Turned out that the defendants ended up bringing many of the people live anyway. But Mark did handle several of the witnesses through satellite transmission. And I would really like for Mark to talk to us about how that worked and some of the tips regarding same, both in the Actos case, and then he did it again in the Pinnacle MDL that he led in Dallas. And he's been doing it with some regularity now, and it's becoming more and more accepted by courts around the country.
Well, and don't you think required in light of COVID? I think this is such a timely issue, Mark.
Yeah. Well, I agree. Let me echo Richard's kind appreciation to Baylor letting us do this and giving us this forum to talk about these incredibly important issues. I think Baylor's foray into this arena of legal education is long overdue. And Baylor, like in so many other litigation fields, is leading the way in this. And hats off to Baylor. Congrats to you guys for running such a great program. Let me also say that I feel a bit awkward even beginning to answer Richard's question, because Richard Arsenault is really the brainchild behind so much of this satellite transmission. He has briefed it. He has carefully worked through the rules. He's argued it before judges, right and left. And to the extent that I've been able to implement this process, I fail to do it properly if I don't tell you that Richard Arsenault is the author of this process. And so anything good that I'm saying is not a reflection of, gee, looky what I did. It's a reflection of, gee, looky what he thought of doing. And so with hats off to Richard, I will answer Richard's question. Satellite transmission of live testimony is something that offers some immediate benefits, but also some precarious pitfalls. For example, we had one witness that we brought by satellite video, and the witness was in a room where the lawyer that attended on behalf of the witness never bothered to look and see what things looked like in the camera. So in a live satellite transmission, you've got a camera that's on the witness, and that witness should have a lawyer present. The lawyer should not only look at the witness, but should go behind the camera and look to see how that witness appears in the camera. The reason why is the lighting was such that you couldn't tell in the room, but to the jury that was watching the video, to say raccoon eyes would be an understatement. This gentleman looked almost Cro-Magnon with his forehead sticking out, with Frankenstein hollowness under his eyes. And I'm not sure that he could have said the sky is blue and gotten the jury to believe him. So you've got some pitfalls that can happen simply because you're making a video appearance. If you have any doubt about this, go back to the very first televised presidential debates. Those were between Nixon and Kennedy. And among the noteworthy points that are made by the media wonks that study those first debates is Kennedy came in wearing makeup. Nixon refused to wear makeup because he thought it an effeminate thing to do. As a result, Nixon looked like Count Dracula on the black and white TV. He might as well have been Bela Lugosi because he looked so transparently bleach white, while Kennedy looked like he was sporting a tan and in great health and vivacious and the young man for America, and Camelot could begin. So you really want to pay attention to those types of details because they can enhance or detract from credibility of a witness. Beyond that, you've got to also make sure that your technology has got the necessary bandwidth to provide for a top quality witness. That means you've got to have the bandwidth for not only seeing the witness, but for the witness seeing you. You've got to have the bandwidth for some type of a presentation device. Our preference is an IPVO, but a lot of people still use the old Elmos. You've got to have the bandwidth to be able to show what you need to show. Now, how does the ordinary lawyer do this? It's easy. You find one of the court reporting services that's done it before. And then you write Richard Arsenault an email saying, can you give me a template order that the judge can enter? Because Richard keeps all of those. And Richard can give you the order, the briefing, everything else. We can give you a list of court reporting services that have done it before and know the bandwidth requirements and all of the pitfalls, and then you go for it.
Mark, I am such a geek. I have an IPVO here. I love this. If y'all don't know what that is, it is a little foldable, portable document camera that literally plugs into the USB port of your laptop and turns the surface next to you into a document camera. And if you've ever struggled with wanting to do demonstratives, and this is an issue now, I know you know, Mark, with video depositions, sometimes you want the witness to make a list. Sometimes you want things to be annotated on the fly. And the whiteboard functions, maybe you're more adept at this than I am, Mark, the whiteboard functions on Zoom and Teams. I already have the handwriting of a serial killer, so it's not really my showcase, but the IPVO is fabulous. I love that tip.
Yeah, we use the IPVO. In fact, they come to my trial academy each fall and have a presentation and a booth, and we give away a certain number of free ones each year. But it is reasonable. It's a couple of $100. The software is incredible. You can set it up to do picture-in-picture so that you've got the document shown, but you've also got the picture of a witness or something like that that's testifying. The editing software is amazing that comes with it, and I'm a big advocate. I don't get any money from them. I'm a big advocate.
Before we move on with technology, Richard, Mark mentioned his trial academy. Would you mind saying a few words about that? Because it takes us off track a little bit, but it really does. If you're going to be managing litigation from the plaintiff's perspective, I think it's a really good resource to know about.
I've had the opportunity, again, to sit next to Mark and help Mark in 5 trials, each of which lasted 3 months. So I've watched a lot of this firsthand. Having said that, he's constantly evolving. I think, Mark, this is the 5th trial academy.
5.0.
Yeah, 5.0. It's the 5th one. And there is new, meaningful, exciting developments with each one. And that's why, 1,000 people show up at these, and everyone from inexperienced lawyers to the most experienced lawyers that I know that want to learn some of these techniques. I've been blessed with the opportunity to watch this in real time, watch it being executed, watching it being prepared. It's an amazing program. He's superhuman. He speaks for over 19 hours. So people need to sign up quickly. It gets filled up quickly, and it's an amazing, amazing program. One thing, Mark, I wanted to follow up with just for a moment on the satellite transmission. You use technology and the use of exhibits, and orchestrating the exhibits remotely becomes a little bit of a challenge because you have, not that you don't have any idea, but you react to what a witness is doing, what the jury is doing, what your opponent is doing. So it's not just a nicely orchestrated, I'm going to use exhibit 1, then exhibit 2. You may not even be sure where you're going. And so you've got to have a counterpart. Well, speak to how that works on the other end.
So what you have to do, in my opinion, and thank you for the kind words about the Trial Academy, it's August 24th through 26th of this year, if anybody, and you can Google, get it on the website. But the nice thing about the way we do this is we've been allowed historically to send a lawyer in. Each side gets one lawyer present at the actual location of the witness. Now, historically, that lawyer's been able, I've sent that lawyer with a set of folders, and I've told that lawyer, these are the folders with these documents. This is the anticipated order, but every folder's got a title, every document's got a number that is intrinsic to that specific segment of testimony, so that if I need to, I can say, Richard, instead of the normal order, would you please pull out document number 14 and set it before the witness? And I would do the same on the IPVO, that device that we've got. And so that type of structure and organization is imperative. We're at a point now, as Liz, you referenced with the COVID situation, where more and more we're going to be seeing witnesses like this. And there will be some courts, I anticipate, will order that the documents be provided significantly in advance, lest there be some transfer of germs and handing over the documents. What we're doing in that situation, or anticipating doing, is preparing the documents, but putting each individual document in a sealed envelope that's labeled, so that that envelope cannot be opened until that document is called forth in the testimony time period, so that the witness doesn't have a chance to see where you're going ahead of time. So I'll supply those documents in a sealed envelope, and I'll be able to say, in the red envelope, look for document number 4, and open that envelope, please. And we'll do it in that process, and then use those. And so we use color, we use numbers, coordinate as best as we can to keep the downtime of finding something to a minimum, so that it runs as smoothly as possible, and yet lives within the confines of whatever the judge's order may be.
So I'm embarrassed to say, when I first started doing work with Mark, we were preparing for a trial, believe it or not, in his basketball arena. And all of the 4 walls, we had 30 lawyers in there, and we had the whole trial sketched out, or at least we were in the process of sketching it out. And I'd seen some of his demonstratives from Vioxx, and I was waiting, when are we going to see these demonstratives, and let's start working on them. And I know some vendors that we can get. Well, little did I know that the demonstratives are created in real time in front of the jury. If you could just speak to that, Mark, for a nanosecond, how you create these in real time, how you show them the map, and then how you use those in your closing.
Well, so I think, as Liz was referencing the IPVO device, anytime you've got that or an ELMO or some other functional device, you basically have a tablet in front of the jury. And so I've got little finicky rules about it. I like to use cardstock instead of paper, because paper bleeds too easily and it crumbles too easily and it's too waffly. But if you get cardstock, a white cardstock, if you use the Papermate markers, they have the more vivid colors that will stand out more clearly, and they maintain their point long enough. Keep a set of Sharpies on hand as well, because sometimes you want to make a more blunt point. But once you've got those, you've got the tools. Now, we're doing this. I'm in my library office, and I can just pick up my computer, my laptop, and I can walk into a different set of shelves that I've got over here to let you know that on my bookshelves, I've got books like 20 Ways to Draw a Doodle. I've got books like 20 Ways to Draw a Mustache. I've got those kinds of books because I read them vociferously. I want to know how I can draw something on the fly. I want to know how I can make a picture that's going to count, and it's not something that's got to be done ahead of time. Now, sometimes it is. I'll tell you, I knew I was going to need to draw a duck in this talc trial that I was doing in St. Louis a couple of years ago, and try as I couldn't draw a duck. But I wanted to draw that duck in front of the jury in real time. It's got to be done fast, and I just couldn't do it. So I got on YouTube. How do you draw a duck? I found something that showed you 4 easy steps to drawing a duck, but I still had trouble. So what I did is, on the inside of the folder that I had that I was using to question this witness on, I had done the 1, 2, 3, 4 steps of how to draw that duck. So the jury doesn't see the inside of the folder. They're just looking at the IPVO device, and I just pick up the yellow marker and I just go 1, 2, 3, 4, and there's the duck. And so they get the duck. Now, they think, boy, he can just draw a duck. I cannot draw a duck. I still can't draw a duck. But there are ways to do this where you learn the techniques so that you're able to create exhibits on the fly. And I'll tell you, it gives credibility to the authenticity of what you're doing. Anyone can pay someone to come up with an exhibit, and the jury will sit there and think, well, this has all been well thought out. But when you create an exhibit right there, real time, on the fly, you draw your own duck, the jury thinks they are caught in an authentic moment, regardless of whether you've planned it or not. And it adds to the credibility, especially with the younger generation that's below the age of 30 who may be on your jury.
So we're going to move on.
Let's duck out of the trial technology and talk about litigation management and technology and discovery.
Well, we do have to talk about technology in terms of digital technology, the production. This will be really quick. Spoliation and litigation holds that are so important. But one last thing on, and a shout out to Rachel Lanier, Mark's daughter, where she came up with the plastic envelope where you could put your opponent's exhibit in there and mark it up pretty aggressively and then capture that, whereas normally you're reluctant to be doing any harm to your opponent's exhibit. Real quick on that, and then we'll move to digital technology.
Yeah, no, that's exactly right. We don't like them to take what we draw on the IP vote and to write on it. It's not right. And so they'll write things on their IP vote because they'll try to do what we're doing. And Rachel said, just get Dad those plastic sleeves that you put the exhibit in. Then you can write on those plastic sleeves because they'll take the ink. Then you can slide their exhibit back out and hand it back to them. And we've been able to annihilate exhibits. Be careful what you write and what you do. Recognize the other side can use it against you.
Okay, real quick on the second part of the technology prong, which is digital discovery, how and when you get it produced, litigation holds, and spoliation. I'm going to go through my 10 tips. And Mark, the last one is spoliation. And I'd like you to address real quickly what happened in the Actos MDL with the first witness being in-house defense counsel and how important spoliation is at the end of the day.
Okay, Richard, before you give your 10 tips, can I just say one thing?
Sure.
And that is, when anybody asks me questions about this, I always say, call Richard Arsenault and ask him his 10 tips. Go.
There you go. All right, number one, real quick, develop a relationship with an electronically stored information vendor. Develop a relationship where they can assist you, and you need to get involved in this at the very embryonic stages of the litigation. That's number one. Number two, preservation letters. Now, the obligations arise as a matter of law, but the preservation letters nevertheless need to go into a lot more detail, and that's the first shot across the bow. Ask for the litigation hold, that should be in place, and ask for its dissemination protocol. And that was critical in what Mark's going to talk about in a moment with regard to Actos. They weren't able to timely produce the litigation hold. There were about 8 different litigation holds, most of which were inconsistent. And that's when we sensed early on in the litigation that we had an issue here. You want to request, this is number 3, request an immediate conference with regard to electronically stored information production. Mark and I were in a case in the Northeast where a defendant cleverly began collecting data before we had an opportunity for the input, and they collected it through search terms as opposed to artificial intelligence or predictive coding. We want predictive coding. That needs to be done. And all of the empirical data, there's no question with search terms. And when you begin a case, you don't understand the language of that defendant. But even with the most robust search terms, you're only getting 20 or 30% of the relevant documents. Whereas with predictive coding, you're getting over 80. And what we're seeing more and more is someone will go out and they'll spend $1 million using search terms, and then they'll go to the court and they'll say, Judge, we've already done this through search terms. They've been used forever. We've spent $1 million. And then the judge said, well, you know, what can we do? And then they say, well, why don't you do the predictive coding on top of what's come out of the search term? So now you're looking at best 20 or 30% of the relevant documents, and you're going to do predictive coding now on that small microcosm. You want native files as opposed to PDF. And I guess the last, before we get to the spoliation, is I think plaintiff lawyers have the bad habit of asking for too much and not narrowing their scope. We're in a different time right now with the phenomena of cost shifting. And many of the defendants are saying, look, if you make us jump through too many ridiculous hoops that are of no moment, you're going to pay for this. And that's a 7-figure tab. And then spoliation, it's occurring with more and more regularity. It's something that digital technology can help us uncover. And Mark, if you can just speak to how important it was. It didn't drive the entire case, but it certainly set the tone and showed some of the bad conduct that was superimposed on the other bad conduct that was the primary source of why we were there.
Yeah, so Richard had this case, and he graciously asked me if I'd come in and try it with him. And it was one that dealt with a company from Japan that had, it seemed to us, thrown away some extremely critical documents, or at least never provided them. And as that became apparent, we had an option of what to do in front of the judge, because the problem was underscored right as we were about to begin the trial. So we weighed options. Do we go ahead and ask for sanctions? Do we ask for depositions now that the other side seems to be allowed to bring a late witness to trial? What do we do? The sanction that we asked for, or what we bartered for, was that the other side would be allowed to have a witness, a new witness, testify about spoliation, but I was allowed to put that witness on first in my case in chief. The witness wound up being an in-house lawyer for the company, and that poor soul stayed on the stand for, Richard, how long? I'm basically
five days.
5 days, and it was finally in the middle of the 5th day that the judge stopped the trial, ordered the jury out of the room, and instructed the witness to go get a criminal lawyer, because the judge was going to report her to the U.S. attorney for perjury. And we would resume on Monday once she had a criminal lawyer. The envelope of what we could do expanded massively by putting a witness on the stand about spoliation. What made that work, however, was all of the groundwork that Richard and others on the team had done in not only discovering the fact that documents had been destroyed, but getting the clues as to what those documents were. And that is made possible if you've got Richard's mind behind this electronic information and you get that information. It's hard to destroy documents and not leave a trail of breadcrumbs that an intelligent lawyer can follow back to the house.
So from a litigation management perspective, if you're thinking, yeah, but I'm not in the billion-dollar club, the takeaways I hope you're hearing from this, and obviously we deal with this extensively in the program. Number one, you have to understand technology. No longer can lawyers afford to be Luddites. We simply don't have that luxury. Number two, if you don't understand it, you need to learn. If Mark Lanier can learn to draw a duck on YouTube, you can learn about data analytics. You can learn about predictive coding. And you actually have an ethical obligation. You know, the ABA has said since 2012, we have to maintain technological competence, which either means doing it yourself or finding the person who can help you draw the duck. And then you've got to have a plan. Listen to how intentionally these gentlemen talk about managing the data, both their own, sending out litigation preservation letters, getting the hold, getting the information, but thinking it all the way through. That is at the guts of litigation management, and I hope you're hearing those themes come through. Could we shift gears now, because you have such expertise? Let's talk about some of the management issues that come with big complex cases like MDLs, when you're thinking about venue, the business plan, all of those litigation management concepts that are implicated in MDL and complex litigation.
So Mark and I visited about threshold considerations, and there are really so many. I've picked venue selection for us to start, but it's not mutually exclusive, and there are a ton. And this is not in lieu of, it's in tandem with many other considerations. But venue selection, and Mark is a great example. He's pivoted from state court to MDL leadership when necessary. In the Vioxx litigation, for example, he was one of the ones that got the largest verdicts in state court. Then in the Actos litigation, leadership position in the MDL there, $9 billion verdict, and leadership position in the MDL in Dallas in the Pinnacle litigation, 5 bellwether trials there, billions of dollars of verdicts. And then most recently, getting a verdict is wonderful. Keeping as much of it as you can is also critical. And yesterday, Mark got I think an 86-page opinion from the Missouri Appellate Court approving $2 billion in damages in his talc case. There, Mark elected to go in state court. And there was most of these cases, there are parallel universes. There's an MDL, and then there's a state court. But, Mark, if you could just kind of maybe from 30,000 feet speak to the kinds of things at the end of the day that move you in one direction or another. I think jury pools, the new jurisdictional rules, availability of punitive damages, availability of multi-plaintiff trials. Can you subpoena the witnesses? What's the appellate court look like? What do the judges look like? Are they going to let you try your case? Will you have to have a chess clock? Do you want a chess clock? Will there be some limit on witnesses? What goes into your gumbo of deciding, all right, in this one, I'm going to state court. In this one, I'm going to the MDL.
Richard, it's every factor you just named, and all of those are critical factors. The only thing I might add to it is you'll understand those better if you speak with lawyers that have experience in the various jurisdictions. So for example, in the Actos litigation, when Richard said, hey, Mark, you want to come in and try this thing with me? My immediate question was, please tell me about the jurisdiction. I want to know about the judge. I want to know about the jury pool. I already knew the Fifth Circuit would oversee this judge, so I knew about the Fifth Circuit. And Richard would walk through all of those different factors. And then we have the question, okay, which case are we trying? Well, this is a case with a New York plaintiff. So what's the New York law on this? Such that lexicon was waived and that case can be tried. A New York case can be tried in Lafayette, Louisiana, of all places. So all of those factors are important. You've got to analyze them, and it's never the kind of thing where everything is a compass pointing to true north. You'll get a different readout on different things, and then you've got to begin weighing it. So you say, okay, well, I've got a judge who's going to let me try my case here, but I've got an appellate court that's going to be extremely strict. Or I've got a jurisdiction where the juries don't tend to be very favorable to my position, but, blah, blah, blah. So you weigh through all of those, and so many people just stumble into what they're doing. And Liz, this goes back to what you were talking about on technology. The same is true in the administration of a case. Don't just play chess move by chess move. Think about it in 3 and 4 and 5 moves in advance. Think through the different possibilities, make a decision tree, and then think through the factors that are involved and make very deliberate choices about what you're going to do based upon what you think is the most likely outcome and scenario. I'll add one last piece to the puzzle. Work with people you know and trust. You can't nobody administers these cases alone. Richard's so kind. Mark won this verdict. Mark won that verdict. No, I was the trial component of a team that won those verdicts. You can't do complex litigation alone. I don't care how thorough you are and how good you are. You've got to have a team. So what goes into that team? You want people you like. As bizarre as it sounds, I've spent more time with Richard than I have most anyone on this planet except my wife for the last 10 years. And periodically, we don't have litigation going right now directly. We're in some cases together, but I call Richard periodically just because I miss him, okay? Because I'm so used to spending time with him. Spend time with people you like and you'll do better. Also spend time with people you trust, and those two often go hand in hand. It's hard to have a relationship without trust because typically, in one sense, Richard and I are competitors. He's got this incredible plaintiff's firm, and he's trying to make sure that he and his massive operation are profitable and do well and are successful. I've got a competing plaintiff's firm where I'm trying to do the same thing. Yet, because of our trust, we're able to integrate without any fear and concern. I'd give Richard the keys to my house, I'd give him the keys to my office, and not have a second thought about it. You want that layer of trust when you're administering these cases. And so if you work with people that you like and you work with people you trust, then you can work through all of these factors Richard's talking about, and you'll be in the right venue doing the right work.
So when you're managing the litigation, Mark, and this is, I found fascinating. I've been mostly in the MDL landscape when I've got 30 different law firms participating. Now that can be a blessing or it can be a curse, depending on the gene pool, right? But I know how many warm bodies, warm, capable bodies with diverse experiences and skill sets it takes to put on this rodeo. In Vioxx, it was you, it was your firm, all right? In Talc, even most recently, okay, it was your firm and local counsel. That, I mean, I watched something like that and say, wow, that's pretty amazing. You've got to have the trial team, you've got that. You've got the appellate counsel with Ken Starr and Professor Arthur Miller and Ken Parker and Michelle. You've got a great appellate team. You are able to do that, and you just did it again with a $4 billion verdict, and the appellate court has said that you get to keep at least $2 billion of that. The challenges, the pros and cons of doing it with a smaller, intimate group, your firm and local counsel, versus the challenges of doing it, pros and cons with a larger group.
Anytime you do it with a larger group, you've got the advantage of spreading out the risk. When I have to do it alone with our firm, then I am in a position where I have to dedicate so many resources to that one project that the investment value increases dramatically, because those are people who can't be doing work on other cases that may be helpful in keeping the law firm on a constant footing. So anytime you can do it with other people, you diversify and spread the risk across the board. Richard and I did the Pinnacle cases together with Jane Conroy from Simmons Hanley Conroy, Wayne Fisher from Fisher Fisher and Boyd, or whatever it was called at the time, and that allowed us to go through litigation for 10 years where we got no income from it, where we spent tens and tens and tens of millions of dollars. And instead of it being one firm, we were able to spread it out amongst all of us. And it made it much easier to handle such a long, extended litigation. So those are the factors that occur to me.
Okay, next is business plan. I think way too many people get into these deals without a business plan. They may have an initial plan, but they haven't really thought through the exit strategies. And I think there have been too many folks that think the litigation is going to settle. That's not been our experience. Cases get tried and they get appealed. And hoping the litigation will settle is not a plan. So you've got to have a business plan from day one. You need to plan on trying cases. You need to plan on trying a lot of cases, and maybe come up with some sort of plan to try all of the cases. Now, recently, you developed a plan where you were going to, after trying 4 or 5 cases, you've tightened the case. You've got the key exhibits. You've got the experts. Now you're going to do tutorials on the East Coast, on the West Coast, in Chicago to start, to teach capable trial lawyers and educate them on what you've done so that all of the cases can be tried. And in my view, cases don't get settled unless the defendants see a viable business model or see some kind of risk. And the viable business model nowadays is you need to be able to demonstrate that you can at least try the bellwether cases. And if they sense that you are going to be tapped out after a few years, and that's all she wrote, you've got to be in a position to say, hey, I've got a plan to try all the cases. And I know my firm can only do so much, but I have a lot of friends. I have a lot of capable colleagues. I've put together the trial package, and we can do this.
Well, and Richard's point is really well taken. Defendants have the ability to use data analytics, especially with tools like Lex Machina, to hop on and see how many cases did Richard Arsenault's firm file on this day? How many people are in that firm? we can look at, because I've spent a lot of my career doing defense work, there's robust data now that lets you look at and predict what is the reach of this particular plaintiff's firm. And so that really does come into play, because that's the alternative strategy is, can we run them down? Can we out-business the business people?
And are you using your money, or are you using OTM, other people's money, at 1.5 points per month? That strikes me as almost unsustainable for certainly if you're doing that over 10 years. Navigating the MDL process real quick, embracing versus avoiding the MDL, strategies for staying in state court, peacefully coexisting in parallel universes. You've just had to do a lot of that in talc. Just general thoughts on how that coordination works. And this is after you've decided where your home is going to be, but there is this other parallel universe that can help or that can hurt. There are rulings that are going to take place there that may or may not influence what you're doing in state court, for example, or vice versa.
Now, I've got two analogies that go in my head for that, Richard. One is plate spinning, because you really are spinning multiple plates. Even if you decide I'm going to be in state court or I'm going to be in the MDL, you've got to keep the plate spinning and knowing what's going on in the other jurisdictions, because what can happen in one jurisdiction with a Daubert ruling on an expert might affect you in a second jurisdiction. Whether or not the expert's deposition goes well in one jurisdiction might affect you in another jurisdiction. And so you've got to spin the plates. You've got to pay attention to more than what is on your own plate. The other analogy that comes to my head is dancing, because not that I'm some dancer, but you've really got to sometimes dance a dance, because every judge would like you to be all in with that court oftentimes, and whether she or he sees you all in to her or his court makes a huge difference in the reception you get there. And so sometimes when you're playing both state and federal litigation, you actually have two judges that both want you really in their court. And you've got to try and dance that as best as you can. So those are my two analogies that work in my head for those issues.
We're just about out of time, but we have enough time, I think, to discuss PSC leadership and how that works at the end of the day. I mean, on a scale of 1 to 10, Mark, how critical is it when you're putting together the PSC that you've got the right chemistry?
On a scale of 1 to 10, 12, 13. I'll tell you this, as Richard tells me, life is too short to be involved in this litigation if you're not able to get along with or trust, or you don't have the camaraderie even that you think will make it something that's a good thing at the end of the day. And that's not to say that they're bad people or something like that. It's just, you're going to be playing in the sandbox, and some people you play in the sandbox more easily with than other people. I'm probably a thorny personality, and some people will be having trouble being in the sandbox with me because of who I am. And those people might say, Lanier, have fun. We'll see you somewhere else. And I may say the same thing about some extremely good lawyers, where it's just kind of like, hey, you guys got this. You don't need me. I'm going to go pick up my toys and play in a different sandbox. I think being in the right seat on the bus is absolutely critical. And a lot of people need to pick and choose where they're going to serve.
Well, I think that's another good point too. Don't you have to play to the counsel's strengths? I mean, how do you coordinate the counsel and the roles that you're going to have on this PSC, Richard?
Well, it would be easy if you unilaterally had the right to select who you wanted to work with, but that's not how it works. You start putting together your organization early on, and then all bets are off depending on where the case lands. And why is that? Because, and there's nothing nefarious about this, the judge may have some idea who the national players are, but maybe not. And I can tell you, In our Pinnacle MDL, this was this judge's first MDL. In our Actos MDL, it was the judge's first MDL. She was not familiar with who the players were. Judge Kincaid in Dallas was not really familiar with who the players were. So what happens? They look to a stalwart, a very well-respected local counsel that they've known for years, that they trust, and they reach out to someone like that. That can radically alter the dynamic, because that person can have his or her own agenda with regard to how these things are run, their own group of people, and suddenly all the plans you've made are undermined. Of course, the judge has to pick the PSC and the leadership as well. And even with guidance from local counsel, there is no telling what's going to happen. And sometimes it's a little awkward to say, Judge, these three lawyers here, I just can't work with them. And I just assume not be on this PSC if I have to work for them. The Manual for Complex Litigation speaks to private ordering. And while the courts are supposed to and do make this decision, they are encouraged to be deferential to allowing the plaintiffs to organize themselves. And then I've seen and I've participated in occasions where we'll do slates, and we'll say, Judge, here's our slate. And if you see fit to appoint this slate, we will work well, and we think that you'll be happy to have us in your court. Having said that, if it's going to be some mutant of that, pick another slate or pick however you like. But if you want us involved, this is the slate we want. So usually there's a hybrid of something like that, but it is disconcerting to know at the end of the day. And of course, defense counsel doesn't have that problem. They get to pick and choose. They know who their strategy counsel is. They know who their trial counsel is. They know who their appellate counsel is. They know who their discovery ESI people are. And they've got a well-oiled machine. We come in like troglodytes who compete against each other, may like each other, may not like each other. So it's an amazing process to watch. And more times than not, if that chemistry is not right, and if you don't have the right group, that PSC is going to be swimming upstream for a long time.
Now, if
becomes
I
a
called you a
Frankenstein.
troglodyte, that wouldn't have gone well.
It becomes a Frankenstein, grabbing body parts from different people, and it's not a pretty sight.
Yeah. Okay, guys, you're right. We are getting close to the end of our time. I'd love each of you to give one takeaway, and then I'll spend just a minute framing how these issues get dealt with in the LLM, because we suspect many of you need to get back to your day/remote desk job. Richard.
I love this practice. I think it's fascinating to have the opportunity after years of having done one-off cases where it's, my firm against another firm, the strategizing, having an opportunity to work with Mark Lanier. People will be talking about Mark Lanier decades from now, and I'll be able to say, I knew him. I got to work with him. It was amazing. The challenges are they're great. They're great. And it's a macrocosm of the individual cases. The risk is great. The reward is great. I would urge folks that want to learn about this to look at the very latest cases, 3M, Jewel, and look at those case management orders, because it's constantly evolving. And the judges now are using special masters more. They're using academicians. Professor Jamie Dodge from Emory is advising a lot of the judges, and she's able to move the litigation in what she thinks is a more efficient manner. And it's what I love about Baylor is the academicians in this particular program actually have tried a lot of cases. They've managed litigation. So it's wonderful to see academicians that have these real world experiences, whereas unfortunately, a lot of academicians around the country that are grading our paper or trying to figure out what we do when we barely can figure out what we do, they come out with what I think are misguided conclusions about who we are, what we are, and what this landscape looks like.
Mark.
So my takeaway from this is what a joy and delight. Whoever dreamed that you could have a career where you could help change the world, where you could do good things, where you could do it working with great people, where you could do it in ways that challenge yourself to learn and to grow and to become more proficient at what you do. And I'm thankful. I'm thankful to God, but I'm thankful to so many others as well for helping me find this place in life that's marvelous. And everybody who's studying this program or who's watching this program or involved in the Baylor program needs to go in with this view of, you know, I can meet the Richard Arsenaults of the world that will be my good friends. I can learn from the Liz Fraley's of the world. I can learn from the Jim Wrens, the Vitos. I can do this type of work in a way where it's not only personally edifying and enriching, but it makes the world a better place. Our Pledge of Allegiance that we learned in elementary school ends with that very powerful phrase, with freedom and justice for all. And that's what we seek to do in the court system. We're pretty fortunate, and it's a great thing.
So this has been just a snapshot of the kind of conversations that we have with our brain trust. And if you're sitting there thinking, yeah, but I haven't actually done an MDL, I haven't been on a plaintiff steering committee yet, the program is designed to walk you through the steps. You heard Mark and Richard talking about forum. We have Professor Roy Ryan, who's just a renowned expert on federal courts, talking to you about how do you look at those issues. We have early case assessment. We have decision tree analysis. We look at damages. We look at the business models. We have the business school type people talking to you about data analytics. We dive deep into the Sedona conference. And so what you end up with is this full trajectory of how you get this. And while you get Richard and Mark's type of input on the plaintiff side, the other thing we do is we pick it up and we look at it from different angles. We'll look at it from the defense angle. We'll look at it from the in-house counsel angle. We'll look at it from the judicial perspective. Because boy, you really understand how litigation gets managed well if you understand the different seats from which each of the participants in that complex setting are looking. So we encourage you, if you are interested, please reach out. V is always available. You can pop on our website and look at that. If you're interested in being taught personally how to draw a duck by Mark Lanier, hop on his website and look at the Lanier Trial Academy. Richard's book, The Manual for Complex Litigation, really puts this all together nicely. If you want that kind of background, gives you the benefit of his insight. But we really, first of all, gentlemen, appreciate your spending your valuable time and sharing your expertise with us. And to all of you who were watching, thank you so much. We really appreciate your time.
Thank you, Liz.
Richard, Mark, thank you guys.
Oh, thank you,
This is
Jim.
outstanding.
Thank you, guys. Appreciate it.
Bye.
Yeah, thanks.